3, 2, 1. Welcome to our session, Top 10 Tips for Contracting an Agent or a Distributor. I am Yendi Alvarez from the World Trade Center Miami. World Trade Center Miami is the organizer of the America's Food and Beverage Show. Now, for those attending this session, please put your questions in the chat box or in the Q&A box, and we'll address them at the end of the presentation. This session will also be recorded and will upload to the platform within 24 to 36 hours after the presentation and will be available on our website at a later time. Now, it is my pleasure to introduce to you Joshua Rodman, Senior Associate of Sandler, Travis, and Rosenberg. Joshua, the floor is yours.
Thank you so much, Yendi, and it's an honor and a privilege to speak with the group today, to those in attendance. With that, I will dive right into the subject matter. I'm going to be focusing on top 10 tips for hiring an agent or distributor. I have my final slide. It contains the actual top 10 tips, but along the way there, I'm going to be talking about various aspects of what companies should be looking at and for in terms of hiring an agent or distributor, and how a company can best go about making that decision in an informed way and in a way that is most advantageous to your company. So there are different strategies for selling overseas. Of course, there is the direct sale strategy where you have a sale from seller to buyer and title transfers to buyer in a two-party direct sale. There's also more complex, potentially more complex way of incorporating abroad, creating a presence abroad, and operating on the ground overseas. And depending on where that is, you can have various types of entities and ways that that can be done. Another method is to use a local agent or distributor, which is very much germane to this discussion, where you have an intermediary, and in the case of a distributor, where you have title transferring for the goods to the distributor. But in an agency relationship, title does not transfer and the agent is merely representing your company abroad. You can establish a local office abroad, which is slightly different than incorporating abroad, but that can be combined with use of an agent abroad as well. And that's something that may be advantageous or not, depending on the particulars of the circumstance. And then, of course, there is the option to create a joint venture vehicle where two or more companies own the interests of the joint venture entity, and burdens of cost, responsibility, and exposure are shared pursuant to an agreement. So there are many different ways that you can sell overseas, and each of these different ways may be a best fit for your company depending on the circumstances. So diving right into the agent versus distributor facts here. Let's just go through them, agent versus distributor, one by one. In the case of an agent, the agent is under the principal's control and direction, whereas when you hire a distributor, that distributor independently conducts business and is not working on behalf of the principal, but is very much its own entity and is independently conducting business. In the case of an agent, the title to the goods at issue does not transfer to the agent. The agent does not purchase and resell merchandise. Rather, they're just facilitating the sale and receiving a commission for that sale. Whereas in the case of a distributor, the goods are actually sold to the distributor, and the distributor purchases those goods and resells them at their own price. And because of that, the distributor bears its own expenses, and depending on their markup on the goods, keeps its own profit. An agent may provide related services such as promoting the principal's product, managing inventory, spare parts, coordinating financing. And in the case of a distributor, there can be a provision of customer and sales information to guide that distributor, but very much they may make their own decisions in that respect. The agent often receives a substantial government protection, whereas in the case of a distributor, that can vary. In the case of an agent bearing a risk of loss, credit risk and potential tax liability, the agent very much does bear that risk of loss, credit risk, and potential tax liability. And as well as in the case of a distributor, the same would apply. In an agency relationship, you would not need to be concerned with the contract with the UN Convention on Contracts for the International Sale of Goods, but that could apply in the distributor relationship, and we will address that shortly. I have here a few items that a company would want to run through in terms of performing due diligence on either an agent or distributor that will help make the business decision. A questionnaire or interview can be performed. You will want to get the names of owners, the managing director, and run as much due diligence on those folks as possible. You want to understand the date that the entity was established, or in the case of an agent, how long the agent has been in business. You may want to collect banking, trade references, just a general reference collection as we see in many facets of life. We want to diligence the financial capability, and this applies more in terms of a distributor for obvious reasons, but that's another critical item. You want to understand location of assets, not only for performance reasons, but to understand where assets are located for purposes of understanding whether that company or person is judgment proof or is beyond the reach of U.S. jurisdiction if a legal issue were to arise, et cetera, et cetera. You'll want to understand the number of employees and turnover in the case of a larger agency outfit, or obviously in the case of a distributor, want to understand sales force, the product categories that the agent or distributor is involved with and has experience with, the firms that they've previously represented, office and branch locations, which also goes to physical presence and location of assets, warehousing and service facilities to understand capacity and related matters. This is a critical item, understanding the territory regularly served, for obvious reasons. If you're targeting a critical territory that's critical to your business or critical to a growth plan, you want to understand whether the agent or distributor has substantial experience and can prove that substantial experience and return in that particular territory. Want to understand the category of customers for very much the same reasons. You want to understand the agent or distributor's business plans and how those business plans may align with your business and how they can actually help sell your product, and whether that's part of their business plan or whether there's some tension there. You want to understand the company's financial projections to the extent you can have face-to-face meetings and visits. More complicated these days, but can be done electronically. But that's another critical item. You'll want to minimize the territory of exclusivity. We're going to get into terms later, but understanding territory and the issue of exclusivity up front is very critical, because to the extent you enter into an exclusive relationship with respect to a territory, that could complicate coordinating or using other agents or distributors in that same territory, and that's very much dependent on the exclusivity provision in the governing agreement. And you may want to consider a trial run, so to speak, with the agent or distributor to see if there is a good working relationship from the outset before a greater commitment is made. So a little short discussion here of important contractual terms, in this case applicable when selling overseas, right? You're going to want to consider whether US law applies, whether the other country's law applies, whether the UN Convention on Contracts for the International Sale of Goods, the CISG, applies. Oftentimes, these matters can be handled by contract, but sometimes certain provisions cannot be waived. And the legal landscape as it pertains to the countries where business activities are being performed can be very complex. And I think a lawyer is very much required to advise on these issues. Sometimes you may need lawyers in multiple jurisdictions to advise on these issues, but these are generally what you want to be thinking about when selling overseas. The CISG, what is it? It's a uniform body of sales law for cross-border sales developed by the UN. And this was created to facilitate or to create a uniform body of law for cross-border transactions in an age where international business had become increasingly viable, vibrant, and very much in use. What are the basics of the CISG? The CISG applies to sales where the parties are in different countries if both of those countries have ratified the CISG. So it could very much apply in a case where one party is in the US and the other party is abroad in a country that has ratified the CISG. As of April of 2020, 91 countries had ratified the CISG, covering about 80% of world trade. Notably, major absentee countries from the CISG are India, England, and South Africa. Many of you may be doing business in those jurisdictions, so that's a key piece to know. And the US adopted the CISG in 1989. Now, notwithstanding the fact that you may be doing business between two countries, both of whom have ratified the CISG can be opted out of by way of agreement or contract or waived. And the CISG tends to favor the seller, but there could be very good reasons why both parties want to opt out of the CISG and to ensure that a different set of rules apply to the transaction between the parties. And that's very much a case-by-case basis, but essentially turns on, to the extent the parties agree, incorporating a body of law and rules that both parties can rely on with certainty and can set out at the outset of the relationship. So basic contractual terms that outside of the CISG that are important in both an agency or a distributor relationship. Parties do want to have a signed agreement drafted by counsel, not to, in contrast with that, not start business on a handshake without a written agreement. This is such a critical piece, even when doing business locally, but even more so when doing business internationally. And you would be shocked to see how many even very sophisticated businesses operate on email terms or very terms that do not constitute a written agreement drafted by counsel. To the extent you have provisions that are subject to change or are very much maybe sensitive to time or could change throughout the duration of the relationship, it's advisable to incorporate the terms that will not change in the body of the agreement and then create an appendix outside of that agreement where the provisions in flux can be located so that every time a change is required, a modification is required, the body of the agreement does not need to be changed, rather just an appendix. You do not want to characterize the agent or distributor representative as an employee in either case. And to the extent that does happen, that can create a lot of headache in terms of tax liability, employee liabilities towards the agent or distributor being treated as an employee. This can vary state to state, but it introduces a lot of unnecessary complexities. You do want to quantify expectations specifically and realistically. We're going to talk about this more, but to the extent the parties can nail each other down on expectations with respect to volume, pricing, and expectations around those items, that's critical and will create more conditions for the parties to walk away to the extent the relationship does not work out. You do not want to exercise control or provide benefits to the agent, distributor, or representative. This goes to the point I mentioned in terms of characterizing either as an employee. To the extent you don't have a written provision that could characterize the agent or distributor as an employee. To the extent a sufficient amount of control is exercised, then in practice, the counterparty could be legally viewed as something that it's not, and introduce some of those same complexities I mentioned earlier. You do want to coordinate with an in-country expert, as I mentioned earlier, to understand the differences that may arise when doing business in a different country and in that specific country than what you're used to in the US. And do not make any assumptions, because various legal regimes and rules that can really shock the conscience in terms of expectations could very much be part of that contract, and or even that relationship where it did not have to be and could have been removed from the agreement very easily by a result of coordinating with an in-country legal expert or otherwise. Do include termination provisions, and don't forget that the CISG could apply. Do include dispute resolution provisions, and do not mix the concepts of agency and distributorship in the contract. I'm going to talk a little bit more about dispute resolution provisions. In some cases, you want to stay away from dispute resolution provisions, but when doing business internationally, there's actually a good reason to include them, and I'm going to get to that in a little bit. Do not mix the concepts of agency and distributorship in the contract. In case that's not obvious, that to the extent the parties intend to have one relationship or the other, the agreement confusing the roles and the terminology of that relationship could mean that when an independent observer, whether it's an arbitrator or a judge, views the agreement by its terms, it might be very unclear what was intended by the parties, and that's not a good place to be in terms of introducing evidence outside of the agreement to establish that, which could be actually prohibited by the terms of the agreement, depending on whether there's a merger clause or some similar clause. So exclusivity is a critical item in terms of both the agency and distributor relationship. To the extent you do have exclusivity, you want to very clearly define actually whether it's exclusive or not. Important clarification. You want to clearly define the territory, product type, product line, distributor channels, and time constraints that would apply to any aspect of the relationship. And you do not want to overstate exclusivity, requiring reduction, not augmentation. And it's very important, and this will be addressed later as well, but it's very important, to the extent you have an exclusive relationship, to give yourself as much flexibility as possible to very clearly define the exclusivity, whether it's by way of a territory or something more specific within that territory. Do condition future exclusivity on sales, purchase quotas, right? And don't overstate non-solicitation. So you want to condition future exclusivity on sales, purchase quotas, because to the extent you lock yourself up with an exclusivity clause with respect to a certain territory, you could very much easily get out of that by having a partner that, if it does not meet expectations, you're able to walk away from that exclusivity. You can see a situation where a company is locked up by way of exclusivity in a certain territory, and the partner is really not doing anything, and legally you have an exclusivity issue in that territory, even though there's not a productive business relationship still occurring. You do not want to overstate non-solicitation. Solicitation goes to whether a company can hire employees or potentially customers, depending on how the term is drafted, away from each other. And so that solicitation provision should be very narrowly drawn to exist during the contractual relationship, and preferably for only a short period of time after, but there could be good reason for it to extend longer in certain circumstances. You do want to consider the ability to carry different brands, and you definitely do not want to ignore antitrust issues. This goes to a practice point I raised earlier in terms of consulting with local experts to see whether there are potential antitrust issues that are implicated by, what would seemingly be a harmless agent or distributor relationship. You do want to consider non-solicitation and confidentiality provisions that extend 3 years after termination of the contract. There could be good reason for that period to be shorter. It's quite hard to get companies to sign up to something longer, and there are compliance complications related to maintaining confidentiality so many years after the end of a relationship. But these can all be addressed with counsel or local experts. And do not forget to safeguard your confidential information in all ways possible, including manifest confidentiality. Otherwise, there is a risk of very much the information being exposed. And counsel can assist with very broad confidentiality provisions that create obligations for both parties to treat confidential information received from either party in the same way that a company would treat its own confidential information, and that's a common standard you see in commercial agreements. For pricing and commissions, you want to reserve right for price changes with specific time for notice, which may have to factor in exchange rate fluctuations and inflation. Do not over negotiate and limit room for purchase and promotional incentives. Definitely want to have as much flexibility on that point as possible. You want to clarify terms of sale and when payments are due. That's a critical item that's often overlooked. The agreement needs to clearly say that payments are made the second Monday of every month. You'd be shocked to see how many times that critical term is left out. You do not want to create price instability for the distributor, and the distributor oftentimes will push back to the extent that that is present. You do want to allow for special promotional efforts by your agent or distributor. You do not want to violate ethical payment standards. You see a notation there with regard to FCPA, the Foreign Corrupt Practices Act, which is a U.S. law, which in short prevents U.S. persons from bribing foreign officials or foreign persons to effectuate business. But most countries in the developed world, including the UK and others, I don't know about most, but many countries have a similar legal regime to the FCPA. So whether that's something to be conscious of, even where theoretically speaking, there is not even a U.S. party involved or U.S. business involved. Do not want to violate foreign exchange control or tax laws. You do want to provide adjustments, have terms that govern adjustments for returned items or canceled orders, as well as consideration of advance commissions and credit terms. So you can see just in the context of pricing and commissions, how thorough and complex these terms can be. International credit terms and payment terms include a focus: open account, consignment or extended terms, time or date draft, documents against acceptance, site draft, documents against payment, cash against documents, cash on delivery, irrevocable letters of credit, confirmed irrevocable letters of credit, cash and advance terms. To the extent these terms are unfamiliar, these do arise in international agreements, and further bolsters the need for experts in the area. And I'm going to fly through a little bit here because I think we only have a few minutes left, and I have a few slides to get through. So for duration of relationship, you do want to avoid unlimited or lengthy periods of representation. You want to keep that very tight so that it can be reevaluated from time to time. Do not provide for automatic renewals. You want a very deliberate renewal process that requires the consent of both parties. Do require joint affirmative action to extend term or renew the agreement, as I just mentioned. Do not omit conditions for renewal or termination, going back to business case issues that I mentioned earlier. Do provide ways to terminate if sales expectations, pricing expectations are not met. Don't include evergreen clauses that allow for automatic renewal without contractual changes being a consideration. Do change provisions periodically to avoid implied automatic renewal. That's somewhat of a complex point, but I think it's self-explanatory. And don't create unnecessarily long relationships that take away flexibility. Do quantify expectations. Don't include ambiguous language regarding those expectations. Do include specific purchase and sales quotas. Don't be unrealistic or out of line with how market conditions may impact those purchase or sale quotas. Do designate promotional and/or marketing efforts, expenses, and who's responsible for those items. And don't set performance standards too high so that what could have been a great relationship is the rug's pulled out from under it before things can even get going. Do require inspections on arrival. Don't forget to include consequences for failure to meet benchmarks. In terms of terminating the relationship, instead of running through one by one, it's very critical to have a thought out termination clause that allows for termination when certain conditions are met or not met, where parties can terminate by mutual consent. You certainly do not want to create avenues of termination at will where one party can walk away without the other party's knowledge or at least even lead time. You want to think about what contractual provisions will apply and for how long after termination. Processes that were in effect and ongoing at the time of termination, how those are dealt with. Termination provisions are not 1, 2, or 3 liners. They really need to take into account these various items. Why is international arbitration a good avenue to include in international agreements? You do not want to be bogged down in international court systems that may be very inefficient compared to ours. Not that ours is the most efficient at all times, but certainly it's more efficient than other countries. But to the extent you have an arbitration provision and a dispute does go to arbitration, an arbitral award is oftentimes much easier to be entered in the United States than a foreign judgment. That's really the key piece. But there could be reasons to depart from this. It's really a case-by-case analysis, but it's an important point to consider. I can address, I think I addressed the critical provisions that are specific to agency and distributorship relationships. I'll pass over this for now. And most importantly, end with the top 10 tips, which is the meat of this presentation and which you'll have access to. You want to decide what role should be played in the deal, whether you really want to work with an agent or a distributorship based on the differences between those two parties. You want to conduct the due diligence that we went through earlier, and that's not an exhaustive list. There could be more due diligence to be performed based on the particulars of the relationship. You do want to obtain the necessary exclusivity, at least explore the possibility of exclusivity based on the relationship. You want to define prices and payment terms, quotas, sales targets, related provisions. You want to be abundantly clear about the duration of the relationship, how it can be terminated, what happens when it's terminated, what happens to ongoing business. You want to confirm the performance standards, as I mentioned earlier. The termination provisions go very much along with the duration of the relationship and introducing as much clarity around that as possible. You want to understand legal restrictions, prohibitions, and policies in place in the local jurisdiction that could impact the agreement as a whole or parts of the agreement or parts of the relationship. You want to understand whether the CISG applies and whether it should be excluded from the agreement by the parties and excluded from governing the relationship between the parties. And critically, you want to protect your IP. You want to be aware of whether there's the potential for infringement based on the local regime that the relationship could be subject to. And along with this, you just want to be abundantly clear on confidentiality obligations. And with that, hopefully there's a minute or two left for questions to the extent the audience has any.
All right, the floor is open for questions. You can leave them in the Q&A box or in the chat box. We'll be up for another few minutes to allow for questions.
My personal email is included in the last slide of the presentation, which I've now put up on the screen, and you guys will have access to this. The audience will have access. My office line is there as well. So to the extent any questions arise in the future, I'd be happy to take those by phone or email.
And to our audience, please keep in mind that any presentation that was provided to us by the presenters will be available on our website in a later time. All right, it doesn't look like we have any more questions other than when the presentation would be available. I will like to close out this session. Josh, thank you so much for participating in our conference. It was a great presentation. Any closing words?
My closing words are, I can't thank you and the audience enough for attending, and please feel free to call or email me to the extent I can be helpful on this or related trade matters.
Great. Thank you so much for attending. Have a great day, everyone.
Thank you.